I used to believe the farm my grandfather left behind, spanning hundreds of acres, was the last place no one had the authority to touch, until one morning when a glossy SUV pulled up against the east fence line and a woman stepped out with the kind of polite smile meant only to mask the arrogance of someone used to wielding power over others. I'd spent half my life working this land, memorizing every truth written into the soil itself. Yet, she handed me a stack of colored documents and declared I was encroaching on the community property of an HOA I'd never heard of. She expected compliance without resistance, but when someone builds their case on forged paperwork, the choice is simple. I document everything, and her fabricated claim becomes the evidence that destroys her. The morning I'm thinking of started the way most mornings did on the property, with light creeping slowly and gold across 200 acres of open grassland that had belonged to my family since my grandfather bought it in 1963. I was near the barn when the silver SUV returned. The woman stepped out with a leather portfolio under one arm. The moment she smiled at me through the chain link, I knew something was wrong. It wasn't the kind of smile you give someone when you're asking for directions or offering help. It was the kind that people use when they've already decided you're going to accept whatever they're about to say. She walked toward the gate with her heels clicking against the gravel, and I stayed where I was, one hand resting on the fence rail, waiting. She introduced herself as Corinne Alder, president of the Riverbend Estates Homeowners Association, and she said it the way people do when they expect the title to mean something. I nodded but didn't say anything, just watched her open the portfolio and pull out a stack of papers clipped together with a heavy black binder clip. She handed them through the gap in the gate and told me I needed to review the documents carefully because several violations required immediate attention. I took the papers and flipped through the first few pages, scanning the headers and the blocks of text underneath. They were printed on glossy stock with a logo in the corner, some kind of stylized tree inside a circle, and the language was formal enough to sound official, even though I didn't recognize a single regulation listed. She pointed to a paragraph near the top of the second page and explained that my property was technically within the boundaries of the HOA's jurisdiction, which meant I was subject to the same rules and fees as everyone else in the community. I looked up from the papers and asked her which community she was talking about, because this land had never been part of any planned development or homeowners association. Her voice took on a sharper edge when she explained that recent rezoning had expanded the HOA's coverage area, and that all landowners in the affected zone had been notified by mail. I told her I hadn't received any notification, and she said that didn't change the facts, that the records showed my property fell within the new boundaries, and I was required to comply with the guidelines starting immediately. I asked to see the records she was referring to, and she tapped the edge of the portfolio and said everything I needed was right there in the packet she'd just given me. I flipped through the rest of the pages, looking for something that resembled a map or a survey document, but all I found were lists of rules about lawn maintenance, exterior paint colors, and parking restrictions, along with a schedule of fees that ranged from $50 for minor infractions to $500 for repeat violations. There was nothing that showed where the HOA boundaries were drawn or how they connected to the property lines I'd known my entire life. I asked her where I could find the actual boundary map, and she said the information was available at the HOA office, and I could request a copy during normal business hours. She glanced at her watch and said she had other stops to make that morning, but she wanted to make sure I understood the importance of bringing the property into compliance as soon as possible, because delays would only result in additional fines. I asked her what exactly was out of compliance, and she gestured toward the barn and said the structure didn't meet the association's standards for outbuildings and would need to be repainted or removed within 90 days. I looked back at the barn, which had been standing on that spot for 40 years and wasn't visible from any road or neighboring property, and I asked her what standard she was talking about. She flipped open her own copy of the documents and read off a section about approved color palettes and materials, her tone flat and procedural, as if reading a recipe. I listened without interrupting, though the absurdity of someone dictating paint colors for a structure no one could see from outside my property wasn't lost on me. When she finished reading, I folded the papers in half and told her I'd look into it. She said that was a good start, but I needed to understand that the HOA had legal authority to enforce its rules, and failure to comply could result in liens or other actions. I didn't respond to that, just nodded once and stepped back from the gate. She closed the portfolio with a deliberate snap, turned without another word, and walked back to the SUV. I stood there holding the folded papers, feeling the weight of something I couldn't name yet, but knew I'd have to deal with. The coffee mug was still sitting on the gatepost, and when I picked it up, the handle was warm from the sun. I drank what was left, even though it tasted bitter. I unfolded the papers and stared at the logo, already planning my next move. The SUV's engine faded into the distance, leaving only the wind moving through the grass and the faint creak of the fence wire settling back into place. I unfolded the papers again and stared at the logo in the corner, trying to remember if I'd ever seen it before, on a sign or a flyer or anywhere that might have warned me this was coming. But there was nothing, just the glossy surface catching the light and a list of demands written by someone who had never set foot on this property until today. I spent the rest of that morning going through the papers Corinne had left with me, spreading them across the kitchen table and reading each page twice to make sure I hadn't missed anything that might explain how my property had suddenly fallen under the control of an organization I'd never heard of. I pulled out the metal filing cabinet and found my deed. I set the papers aside and pulled out the metal filing cabinet in the corner of the room, the one that held every deed, survey, and tax record related to the property going back to when my grandfather first bought it. The deed was right where I'd left it, tucked into a manila folder with the county seal embossed on the cover, and I laid it flat on the table next to the HOA documents. The legal description was clear, written in the precise language that surveyors use when they mark boundaries, referencing section lines and quarter sections and distances measured to the foot. I traced the description with my finger, matching it against the mental map I'd built over years of walking the property, and there was no question that the land was mine, free and clear, with no easements or restrictions beyond the standard county ordinances. The parcels surrounding mine were farmland owned by families I'd known for years, and the only development anywhere near me was a subdivision called Riverbend Estates that sat a full mile to the west, separated from my property by a county road and a wide drainage easement. I'd driven past the entrance to that subdivision 100 times, but I'd never had any reason to think it had anything to do with me. I folded the deed back into its folder and picked up the HOA packet again, flipping to the page that listed contact information. There was an office address, a phone number, and an email, all formatted neatly at the bottom of the last page beneath a block of text about dispute resolution procedures. I considered calling right then, but I decided against it, because I wanted to see the office in person, wanted to look at whoever was behind this and ask them directly how they thought they had any claim to property that didn't belong to them. I pulled my phone from my pocket and typed the office address into the map application, and it came back with a location inside the Riverbend Estates subdivision, in a small commercial plaza near the entrance. I memorized the route and set the phone down. Then I gathered up all the documents and put them back in the folder, keeping everything organized so I could bring it with me when I went. The drive to the subdivision took less than 15 minutes, following the county road west until I reached the brick pillars and turned onto the main boulevard that cut through the center of the development. The houses on either side were new, built within the last 5 or 6 years, with vinyl siding and 2-car garages and lawns that looked like they'd been measured with a ruler. Every mailbox was the same height. Every tree planted along the curb was the same species, spaced at identical intervals. It was the kind of neighborhood where conformity was the whole point, where the rules weren't just suggestions, but the foundation of the entire community. And I could see why someone like Corinne would feel comfortable wielding power in a place like this. I followed the boulevard to the commercial plaza and parked in front of a narrow office with a sign in the window that read Riverbend Estates HOA, in the same stylized font as the logo on the papers. The office was small, just a single room with a desk, a filing cabinet, and a corkboard covered in flyers about upcoming community events. A woman sat behind the desk, younger than Corinne, with her hair pulled back in a tight ponytail and a name tag that said Rachel clipped to her shirt. She looked up when I walked in and smiled the kind of smile that people use when they're working customer service. Polite, but not particularly warm. I introduced myself and told her I needed to see the boundary map that showed how my property was included in the HOA's jurisdiction, and her smile faded slightly as she asked me to repeat the address. I gave it to her, and she turned to her computer and typed for a moment, her eyes scanning the screen before she looked back at me and said she'd need to pull the file. She stood and walked to the filing cabinet, opening one of the drawers and flipping through a row of folders until she found the one she was looking for. She brought it back to the desk and opened it, spreading out several pages of printed documents, and I leaned forward to see what she was looking at. The top page was a map, printed in color, with the subdivision boundaries marked in red and a shaded area extending outward from the western edge. I pointed to the shaded area and asked if that was supposed to represent the expanded coverage zone, and she nodded, though her expression suggested she wasn't entirely confident in what she was looking at. I asked her where the survey data came from that defined that boundary, and she said she'd have to check with Corinne because she wasn't authorized to discuss zoning changes. I asked when Corinne would be available, and Rachel glanced at the calendar on her desk and said she could schedule an appointment for later in the week. I told her that wouldn't be necessary, that I'd follow up directly, and I took a photo of the map with my phone before she could object. She started to say something about policy, but I thanked her and walked out before the conversation could go anywhere that might complicate things later. I sat in my truck in the parking lot for a moment, looking at the photo on my phone, studying the way the shaded area stretched across the county road and over land that clearly wasn't part of any planned community. The boundary line didn't follow any natural feature or existing property division. It just expanded outward in a way that seemed arbitrary, as if someone had drawn it with the sole purpose of capturing as much territory as possible. I saved the photo and started the engine, already thinking about the next step, which was finding out exactly who had approved this expansion and whether anyone had bothered to verify that the land they were claiming actually belonged to them. The photo I'd taken at the HOA office stayed on my mind for the rest of that day and into the next, not because it showed anything particularly complicated, but because the shaded area extended across the county road in a way that ignored every logical boundary marker, cutting through land that had been privately owned for as long as anyone could remember. I printed the photo that evening and taped it to the wall above my desk, next to the copy of my deed, and I spent an hour staring at the two documents side by side, trying to understand how someone could look at those lines and convince themselves they had any authority over property that clearly didn't belong to them. The more I looked, the more it became obvious that the expansion wasn't based on any legitimate rezoning. It was just someone deciding they wanted control and drawing a line to make it happen. 2 days later, Corinne came back. I was outside near the fence line, checking the posts along the eastern boundary where the ground had shifted slightly during the last storm. When her SUV returned, I kept working on the post I was resetting until her heels clicked on the gravel behind me. Her heels clicked against the gravel as she walked toward me, and when I finally straightened up and looked at her, she was holding another folder, this one thicker than the first. She didn't smile this time, just stood there on the other side of the fence with her arms crossed, and asked if I'd had a chance to review the compliance requirements. I told her I had, and I asked her again about the boundary map, the real one, not the colored printout that someone had made in an office without any reference to actual survey data. She opened the folder and pulled out a single sheet of paper, holding it up so I could see it through the chain link. It was another map, but this one had more detail, with property lines marked in thin black ink and a series of annotations along the edges that referenced county records and plat numbers. She pointed to a section near the center and said that according to the most recent filing, my property fell within the jurisdiction of the HOA as of 6 months ago, when the county had approved a boundary extension as part of a larger infrastructure project. I asked her which infrastructure project she was talking about, and she said it was related to road improvements and utility easements that were supposed to benefit the entire area. I told her I would do exactly that, and she folded the map back into the folder and said she appreciated my diligence, but it wouldn't change the fact that I was currently in violation of multiple regulations and needed to begin remediation immediately. She listed them off one by one, starting with the barn and moving on to a section of fencing that she claimed didn't meet setback requirements, then to a gravel driveway that apparently needed to be paved or removed, and finally to what she described as unauthorized outdoor storage, which turned out to be a stack of firewood I'd been keeping near the back of the barn for the past 2 winters. I listened to the whole list without interrupting, and when she finished, I asked her how much it was going to cost to fix all of these violations. She consulted the folder again and said the fines would total around $1,200 if I brought everything into compliance within 30 days. But the amount would increase by $200 for every additional week of delay. I asked her if she was serious, and she looked up from the folder with an expression that suggested she didn't appreciate the question. She said the fines were clearly outlined in the documents she'd provided during her first visit, and if I had concerns about the amounts, I could attend the next HOA board meeting and request a hearing. I asked when the next meeting was, and she said it was scheduled for the following Thursday evening at 7 p.m. in the community center inside the subdivision. I told her I'd be there, and she said that was fine, but it wouldn't stop the clock on the compliance deadlines. She handed me another copy of the violation notice, this one printed on letterhead with the HOA logo at the top, and a long list of dates and dollar amounts at the bottom, and she told me to keep it for my records. Before she left, she pulled out a camera and took photos of the barn, the fence line, and the driveway, saying the board would need documentation for the enforcement file. I asked if she had a warrant or permission to photograph my property, and she said HOA bylaws gave the board inspection rights. I told her those bylaws didn't apply here, but she'd already gotten back in her SUV. She drove away without waiting for a response. I stood there, holding the notice, reading through the list of violations again, and the absurdity of it hit me harder than it had the first time. The barn had been standing for 40 years without anyone complaining. The fence had been built to county specifications and inspected when it was installed. The driveway was gravel because that was what made sense for a working property, not a suburban neighborhood where appearances mattered more than function. And the firewood was sitting on my own land, nowhere near any property line or public right-of-way, doing nothing except waiting to be burned when the weather turned cold. None of it was a violation of anything except the arbitrary rules that Corinne and her board had decided to impose on property they had no right to control. I went back inside and called the county clerk's office, and after being transferred twice, I reached someone who could pull up records related to boundary changes and infrastructure projects. I gave them the plat number from the map Corinne had shown me and asked if there had been any approved extensions to the Riverbend Estates HOA jurisdiction within the last year. The clerk put me on hold for several minutes, and when she came back, she said there was no record of any boundary extension related to that subdivision. I asked her to check again, giving her the specific time frame Corinne had mentioned, and she said she'd already searched the database going back 2 years, and there was nothing that matched. I asked if it was possible the filing had been submitted, but not yet processed, and she said that anything submitted would show up in the system within 72 hours. So if it wasn't there now, it had never been filed. I thanked her and hung up, and I sat at the desk for a long time, staring at the violation notice and the map taped to the wall. Corinne had told me the expansion was part of the public record, that it had been approved by the county, that everything was legitimate and official and beyond dispute, but the county had no record of it. People who carry folders full of documents and cite plat numbers and reference county approvals don't make that kind of mistake by accident. They make it because they assume no one is going to check. I picked up my phone and took a photo of the violation notice. Then I opened a new document on my computer and started making a list of every claim Corinne had made, every document she'd referenced, and every deadline she'd imposed. If she wanted to play this game with fake authority and manufactured rules, I was going to make sure I had a record of every move she made. The HOA board meeting was held in a community center at the back of the Riverbend Estates subdivision, a low brick building with large windows and a parking lot that was already half full when I arrived Thursday evening. I parked near the entrance and grabbed my folder from the passenger seat, the one with copies of my deed, the violation notices, and the notes I'd been keeping since Corinne's first visit, then walked across the parking lot and through the front doors. The meeting room had rows of folding chairs arranged in front of a long table where 5 people sat with nameplates and water bottles. Corinne was in the center, her posture straight and her expression neutral, and the others were spread out on either side of her. There were maybe 30 people in the audience, and I found a seat near the back where I could see the entire room. A man sitting next to me nodded and asked if this was my first meeting, and I said it was. He told me his name was Nolan Reyes, that he lived on the north side of the subdivision, and that he came to most of the meetings because he liked to know what the board was deciding before it affected his property. The meeting started at 7 p.m. exactly, with Corinne calling the room to order and running through a list of agenda items that included budget reports, landscaping contracts, and proposed changes to parking regulations. I listened without saying anything, watching the way she conducted the meeting with the kind of efficiency that came from doing it many times before, moving from one topic to the next without leaving much room for questions or discussion. When she reached the section on compliance violations, she paused and looked down at a sheet of paper in front of her. Then she called out 3 addresses and asked the owners to remain after the meeting to discuss remediation timelines. My address wasn't on the list, which told me she wasn't planning to bring it up publicly. I waited until the agenda items were finished, and Corinne asked if there were any questions or concerns from the audience. A few hands went up, mostly people asking about maintenance schedules or clarification on specific rules, and she answered each one with the same measured tone she'd used throughout the meeting. When the questions stopped, I raised my hand, and she looked at me for a moment before acknowledging me with a nod. I stood up and introduced myself, giving my name and address, and I said I had a question about the HOA's jurisdiction over properties that weren't part of the original subdivision. The room got quieter, and I could feel people turning in their seats to look at me. Corinne's expression didn't change, but there was a slight shift in her posture, a tightening around her shoulders that suggested she knew where this was going. She said that all properties within the HOA's jurisdiction were subject to the same rules and regulations, regardless of when they were built or who owned them. I asked her to clarify what she meant by jurisdiction, specifically whether it included properties that had been privately owned before the subdivision was developed. She said that the jurisdiction had been expanded through a county-approved process, and that all affected landowners had been notified. I told her I'd already requested that approval from the county clerk's office, and they had no record of any boundary extension related to the Riverbend Estates HOA. The room got even quieter, and I saw a few people exchange glances. Corinne leaned forward slightly and said that if there was a discrepancy in the records, it was likely due to a filing delay or administrative error, and she would follow up with the county to ensure everything was properly documented. I asked her if she had a copy of the approval document with her, and she said she didn't bring the full administrative file to board meetings, but she could provide it at a later date. Nolan spoke up from the seat next to me, asking what the protocol was for resolving that kind of discrepancy when county records didn't match the HOA's claims, and Corinne said the board would work with the county to clarify the records. I thanked her for her time and sat back down, and the meeting continued for a few more minutes before Corinne adjourned it. People started filing out of the room, some of them stopping to talk in small groups, and Nolan turned to me and asked if I wanted to get a coffee and talk through what had just happened. We drove separately to a diner a few miles down the county road, and once we were seated in a booth near the back, Nolan asked me to walk him through everything from the beginning. I laid out the timeline, starting with Corinne's first visit and ending with the call to the county clerk, and he listened without interrupting, his pen moving steadily across the page of his notebook. When I finished, he looked up and said he worked in land surveying and had dealt with HOA boundary disputes before, and what I was describing sounded less like an administrative error and more like someone trying to manufacture jurisdiction where none existed. He asked if I'd considered getting a lawyer involved, and I said I had, but I wanted to understand exactly what I was dealing with before I spent money on legal fees. He closed his notebook and said that made sense. Then he offered to help me pull together the documentation I'd need to prove my case, starting with a full title search and a comparison of the HOA's claimed boundaries against the actual county records. He said he had access to the county's GIS database through his work and could pull the official plat maps that showed every recorded boundary change in the area over the last 20 years. I asked him how long that would take, and he said he could have the information by early next week if I gave him the property details. I slid a copy of my deed across the table, and he glanced at it, then folded it and tucked it into his notebook. He said he'd also check to see if any easements or encumbrances on file might give the HOA a foothold. Though from what I'd told him, it didn't sound like there would be. I thanked him and he said not to worry about it, that he'd seen too many people get pushed around by HOAs that operated on bluff and intimidation rather than actual legal authority, and he was glad to help someone push back. We finished our coffee and headed out to the parking lot, and before we got into our separate vehicles, Nolan told me to keep documenting everything Corinne said or did, because if this ended up in front of a judge, the more evidence I had of her overreach, the better. I said I was already doing that, and he nodded, said he'd be in touch, and drove off. I sat in my truck for a moment, looking back toward the direction of the subdivision, thinking about the way Corinne had deflected every question without actually answering any of them. She was good at it, practiced, but the more she avoided giving me real answers, the more certain I became that there weren't any real answers to give. Nolan called me the following Tuesday afternoon while I was out checking the fence line near the back of the property, and I could hear the sound of traffic in the background when I answered. He said he'd pulled the records I'd asked for and wanted to go over them in person because there were some things he thought I should see for myself rather than trying to explain over the phone. I asked him when he was available, and he said he could meet me at the diner in an hour if that worked. I told him it did, and I finished what I was doing and drove out to meet him. He was already sitting in the same booth we'd used before when I arrived, with a large manila envelope on the table in front of him, and a cup of coffee that looked like it had been sitting there long enough to go cold. I slid into the seat across from him, and he pushed the envelope toward me and told me to take a look. I opened it and pulled out a stack of documents, the top one being a printed map with color-coded property lines and a grid overlay that showed section numbers and coordinates. He pointed to a section near the center and said that was my property, marked in green, and the subdivision was the cluster of smaller parcels to the west, marked in blue. The county road and drainage easement ran between them with no overlap, no extension, no connection of any kind. He pulled out another sheet, this one a printout from the county's official plat database, and he pointed to the date stamp at the bottom. The printout showed the last boundary change was 4 years ago. Nothing since. I asked him what that meant in practical terms, and he said it meant that Corinne's claim of expanded jurisdiction had no legal basis. The HOA didn't have authority over my property. Never had. And unless someone went through the proper channels and got county approval, which would require notifying me and giving me a chance to contest it, they never would. I asked him if there was any way she could have gotten around the notification requirement, and he said no, that the county was very strict about notifying affected landowners because of the legal liability involved. He said if she'd tried to file for an extension without notifying me, the application would have been rejected immediately, and if she'd tried to forge the approval, that would be a criminal matter. I looked at the map again, tracing the boundary line with my finger, and I asked him if he thought she knew the claim was false or if she genuinely believed the HOA had jurisdiction. He leaned back in his seat and said that based on the way she'd handled the board meeting, deflecting questions and promising documentation she never produced, she knew exactly what she was doing because people who make honest mistakes provide proof immediately to clear up confusion, while people running a bluff keep stalling and hoping the other person gives up first. I told him about the second map Corinne had shown me, the one with the annotations and plat numbers, and I asked if there was a way to verify whether those numbers were real or just something she'd made up to make the document look official. He pulled out his phone and opened an app that connected to the county's GIS system, and he typed in the plat numbers I'd written down from the map. The app loaded for a few seconds, then came back with a message that said no records found. He showed me the screen and said that confirmed the map she'd shown me was either completely fake or referenced filings from a different jurisdiction that had nothing to do with my property. I asked him what I should do with this information, and he said the first step was to document everything and send a formal letter to the HOA board disputing their claim of jurisdiction and demanding that they cease all enforcement actions against my property. He said the letter should reference the county records, include copies of the plat maps and database printouts, and make it clear that I was prepared to take legal action if they continued. He said I should also send a copy to the county attorney's office, because if the HOA was claiming county approval that didn't exist, the county had an interest in stopping that behavior before it caused problems for other landowners. I asked him if he thought that would be enough to get Corinne to back off, and he said it depended on whether she was willing to risk exposure. But most people who operate on bluff fold pretty quickly once they realize the other person has actual evidence. I thanked him for pulling the records and for walking me through everything, and he said it wasn't a problem, that he was glad to help. He gathered up the documents and put them back in the envelope. Then he slid it across the table to me and said I should keep them in a safe place because I'd probably need them if this ended up in court. I asked him if he thought it would come to that, and he said he hoped not, but I should be prepared for the possibility. He said that people who go as far as Corinne had gone, fabricating documents and threatening fines, don't usually back down just because someone asks them to. They back down when they realize they're about to face consequences that are worse than whatever they were hoping to gain. We left the diner and walked out to the parking lot, and before we got into our vehicles, he told me to let him know if I needed anything else, that he had contacts at the county if things got complicated. I said I would, and I drove back to the property with the envelope sitting on the passenger seat, thinking about what Nolan had said about people who operate on a bluff. Corinne had been so confident during both of her visits, so certain that I would accept her authority without question. And I wondered how many other people she'd done this to. How many had paid the fines or made the changes she demanded without ever checking to see if she actually had the right to make those demands. I parked near the barn and headed inside to draft the letter Nolan suggested. That evening, I sat at my desk and drafted the letter Nolan had suggested, laying out each piece of evidence in sequence and citing the specific county records that contradicted every claim Corinne had made. I attached copies of the plat maps, the database printouts showing no boundary changes, and the GIS search results showing her plat numbers didn't exist. The letter was 3 pages long by the time I finished, and I read through it twice to make sure every statement was accurate and every reference was verifiable. I printed 2 copies, one for the HOA board and one for the county attorney, and I sealed them in envelopes with delivery confirmation so there would be a record of exactly when they were received. I took the envelopes with me the next morning and dropped them at the post office, and as I walked back to my truck, I felt the weight of the situation shift slightly. No longer something being done to me, but something I was actively dismantling, piece by piece, with the only tools that mattered: facts, records, and the truth. The response from Corinne came 8 days after I mailed the letters, not in writing, but in person, and not alone. I was outside working on the irrigation line that ran along the southern edge of the property when I heard multiple vehicles approaching, and when I looked up, I saw her silver SUV leading a convoy that included 2 pickup trucks and a sedan I didn't recognize. They pulled up to the gate in a line, and Corinne got out first, followed by 4 other people, 3 men and 1 woman, all of them dressed in business casual and carrying folders or tablets. I set down the wrench I'd been using and walked toward the fence, wiping my hands on my jeans, and I could tell from the way they were standing, close together in a group with Corinne at the front, that this wasn't going to be a friendly conversation. She didn't bother with pleasantries this time, just held up a copy of the letter I'd sent and asked if I understood the seriousness of making false accusations against the HOA board. One of the men standing next to her, a tall guy with graying hair and a tie that looked like it had been loosened in frustration, stepped forward and introduced himself as the HOA's legal counsel. He said the board had reviewed my letter and found it baseless, that my refusal to comply was willful noncompliance, and the penalties had just increased significantly. I told them I hadn't made any false accusations, that everything in the letter was supported by county records, and if they had evidence to the contrary, I'd be happy to review it. I pulled out my phone and opened the photo of the county GIS search results, showing no records found for the plat numbers Corinne had provided, and I held it up so they could see it. I asked how they could claim proper filing when the county had no record of it. He glanced at the screen, then at Corinne, and said that discrepancies in database updates were common and didn't invalidate the underlying approvals. I told him the county clerk confirmed directly that no applications had been submitted in 3 years, so unless he had documentation proving otherwise, we were done discussing jurisdiction. Corinne cut in, her voice sharper than before, saying this conversation was pointless because I was clearly determined to obstruct the board's authority regardless of the facts. She said if I continued, the HOA would file a lien against my property for unpaid fines, pursue an injunction to force compliance, and schedule a formal hearing to address my non-compliance. I asked her how she planned to file a lien against property that didn't fall under her jurisdiction, and she said that was for the court to decide, not me. I told her the court would need to see the same county records I'd already provided, and those records showed her claim was false. So unless she had something new to present, she was wasting her time and mine. The woman standing behind Corinne, shorter and younger, with a tablet clutched against her chest, spoke up and said that the board had received multiple complaints from residents about my property being an eyesore and a nuisance, and that the community had a right to maintain standards. I asked her which residents had complained, since my property wasn't visible from any of the homes in the subdivision, and she said the complaints were confidential but had been forwarded to the county planning department. I told her I'd be happy to contact the planning department myself and verify that, and she looked down at her tablet without responding. The lawyer stepped forward again and said the board was prepared to offer a settlement, that if I agreed to bring the property into compliance within 60 days and pay a reduced fine of $500, they would drop any further enforcement actions. I asked him why I would pay a fine for violations I hadn't committed under an authority that didn't exist, and he said it was a gesture of good faith that would allow both parties to move forward without litigation. I told him I wasn't interested in good faith gestures. I was interested in seeing proof that the HOA had any legal standing to make demands of me in the first place, and until I saw that proof, there was nothing to settle. Corinne's face tightened, and she said I was making a mistake, that the board had resources and legal support I couldn't match, and dragging this out would only make things worse for me. I told her I'd made my position clear in the letter, and unless she had county-approved documentation showing her jurisdiction extended to my property, there was nothing more to discuss. She stared at me for a long moment, and I could see the frustration building behind her eyes, the realization that I wasn't going to fold the way she'd expected. She turned to the lawyer and said something I couldn't hear. Then she turned back and said the hearing would be scheduled within 2 weeks, and I would be notified in writing. I told her to include all the supporting documentation she kept promising, but never delivered. And she turned without another word and walked back to her SUV. The rest of the group followed her, climbing into their vehicles and pulling away in the same formation they'd arrived in, and I stood there watching them go, my pulse still elevated from the confrontation. Showing up with a lawyer and a group of board members to intimidate me into settling told me everything I needed to know. She didn't have the documentation, and every move she made from this point forward was designed to avoid producing it. 2 days after they left, I received a certified letter from a title company, asking me to contact them regarding a lien filing notice. I called immediately and learned that the HOA had submitted preliminary paperwork to place a lien on my property for $1,200 in unpaid fines. The title officer said it hadn't been processed yet because the HOA hadn't provided proof of jurisdiction, but the attempt was on record. I thanked her and added that detail to my documentation. I walked back to the irrigation line and picked up the wrench, but I couldn't focus on the work anymore. My mind was already moving ahead to the hearing, making sure I walked into it with every piece of evidence organized and ready to present. I pulled out my phone and called Nolan, and when he answered, I told him what had just happened. He listened without interrupting, and when I finished, he said it sounded like Corinne was escalating because she knew she was losing control of the narrative. He said if she were scheduling a hearing, it would probably be another HOA board meeting, not a legal proceeding, which meant it would have no actual authority, but would be designed to make me look unreasonable in front of the community. He said the best thing I could do was attend, stay calm, present my evidence clearly, and let her credibility collapse under the weight of her own contradictions. He said he'd be there with me if I wanted backup. I thanked him and hung up, standing there for a moment looking out at the land, and I realized that the moment I'd stopped accepting her claims at face value and started demanding proof, the authority she'd tried to wield over me had evaporated completely. The hearing notice arrived 11 days later in a certified envelope with the HOA logo embossed on the corner, and when I opened it, I found a single page with the date, time, and location of what they were calling a compliance review hearing. The language was formal, structured like a legal document, but there was nothing in it that explained what authority the hearing had or what jurisdiction it was operating under. It warned that failure to appear could result in default judgment and immediate enforcement action. I read it twice, took photos of both sides, and set it aside with the rest of the documents I'd been collecting. The hearing was scheduled for the following Thursday evening at 7 p.m. in the same community center, and I spent the days leading up to it organizing every piece of evidence into a single folder with tabs and page numbers. I had my deed, the county plat maps, the GIS search results, the database printouts, the letter from the county clerk, and a timeline of every interaction with Corinne. Nolan offered to come with me, and I accepted, because having someone who understood surveying would make it harder for Corinne to dismiss the evidence as misinterpretation. We arrived 15 minutes early, and the parking lot was already filling up. The meeting room had been set up differently, with the board table at the front and a single chair facing it in the center, like a courtroom setup. The audience seats were nearly full, more people than I'd seen at the first meeting. Corinne was already seated at the board table with the same 4 people, and the lawyer was at the end, with a thick binder open in front of him. Corinne called the hearing to order at exactly 7 p.m. and read from a prepared statement outlining the purpose of the meeting, which she described as a formal review of compliance violations. She called my name and asked me to take the center seat. Nolan followed and sat in the front row, and I walked forward carrying my folder. Corinne started by reading through the list of violations: the barn, the fencing, the gravel driveway, the firewood storage. She said that despite multiple notices, I had refused to comply and had instead sent a letter to the county attorney making false claims about the HOA's jurisdiction. She said this demonstrated willful disregard for the community's welfare and required decisive action. She asked if I had anything to say in response, and I stood up and opened my folder. I said I had 3 things to address. First, I held up my deed and the county plat map and explained that my property had never been part of any planned development or homeowners association. I pointed to the map and showed where the subdivision boundaries ended and where my property began, separated by a county road and drainage easement, with no overlap and no legitimate basis for the HOA to claim jurisdiction. Second, I held up the printout from the county database showing the last recorded boundary change had been 4 years ago, and I read the confirmation from the county recorder stating no applications for extensions had been submitted since then. Third, I held up the GIS search results showing that the plat numbers on Corinne's map didn't exist in the county system, and I asked the board how they could enforce regulations based on a jurisdiction with no legal foundation and documents referencing non-existent filings. The room went completely silent. Corinne's expression had gone rigid, and the lawyer was flipping through his binder. I said I wasn't refusing to comply with legitimate regulations. I was refusing to accept the authority of an organization that had fabricated its claim to my property, and if the board had documentation contradicting what I'd just presented, this was the time to produce it. I asked which agencies, and he said the county planning department, the utility district, and the state environmental office. I asked if he had any correspondence or filing receipts, and he said that information was confidential during the review period. I asked how long the review period lasted, and he said it varied. I asked for an estimated timeline or a case number I could use to verify the status, and he said he'd have to consult with his client before releasing that information. Nolan stood from the front row and asked if he could address the board. Corinne hesitated before nodding. He introduced himself, explained he worked in land surveying, and said he'd reviewed all the county records. He said boundary extensions required public hearings, notification of affected landowners, and formal approval by the county board of supervisors, and none of those things had happened. He said the GIS database was updated within 72 hours of any filing, so if an application had been submitted 6 months ago, it would be in the system. He said the lawyer's claim about multi-agency coordination and confidential review periods didn't align with how the county actually processed boundary changes, and if the board had legitimate documentation, there was no legal reason they couldn't produce it right now. The lawyer started to respond, but Corinne cut him off and said the board would take the matter under advisement and issue a written determination within 30 days. I said that wasn't acceptable, that the whole point of this hearing was to review the evidence and decide. And if the board couldn't provide documentation after multiple opportunities, then there was nothing to take under advisement. I said the violations were based on regulations that didn't apply to my property. The fines were legally unenforceable, and any attempt to file a lien or take further action would be met with a formal complaint to the county attorney and a request for an injunction against the HOA. The room erupted in murmurs, and several people started talking loudly. One man near the back stood and asked Corinne if what I was saying was true. If the HOA had been claiming jurisdiction over property it didn't control, and she told him this wasn't the time for general questions. Another woman asked if the board had ever verified the boundary extension before sending violation notices, and Corinne said the board relied on legal counsel and didn't conduct independent surveys. A third person asked why the lawyer couldn't just show the approval documents if they existed, and the room got louder, people calling out questions and talking over each other. Corinne stood and said the hearing was adjourned, that the board would review the information and provide a written response. I said I'd be waiting for that response, and I'd be forwarding a copy of tonight's proceedings to the county attorney, along with a request for an investigation into fraudulent jurisdiction claims. She didn't respond, just gathered her papers and walked toward the door with the lawyer and the other board members following. The audience was still talking, some forming small groups, others approaching me to ask questions or express support. Nolan came over and said that it went better than he'd expected, that Corinne had lost control of the room the moment she couldn't produce documentation, and once the county attorney got involved, the HOA would have no choice but to drop the enforcement actions. We walked out to the parking lot, and I could still hear voices from inside the community center. I thanked Nolan, and he said it was no problem, that he was glad to see someone stand up to the kind of overreach that gave HOAs a bad reputation. I got in my truck and sat there for a moment, looking back at the building, and I realized that what had just happened wasn't just about my property anymore. It was about every person in that room who'd started to question whether the authority they'd been accepting was actually legitimate. Corinne had built her power on the assumption that no one would check, and the moment someone did, the entire structure had started to crumble. The written response from the HOA board arrived 6 days after the hearing, delivered by certified mail in the same way the hearing notice had been. I opened it standing at the kitchen table, and the letter was short, less than a full page, with language that was carefully neutral and stripped of the aggressive tone Corinne had used in every previous interaction. It said that after reviewing the evidence presented at the hearing, the board had determined that further investigation was needed to clarify jurisdictional boundaries, and all enforcement actions against my property were being suspended pending the outcome of that investigation. It said the board appreciated my cooperation and looked forward to resolving the matter in a way that served the interests of the entire community. It was signed by all 5 board members, but Corinne's name was listed last instead of first, and her signature looked rushed compared to the others. I read it twice, then I set it down and called Nolan. He answered on the second ring, and I told him about the letter. He asked me to read it to him word for word, and when I finished, he was quiet for a moment before saying that the language was a retreat, that suspending enforcement actions was the board's way of backing down without admitting they'd been wrong. He said the phrase about further investigation was meaningless because there was nothing to investigate. The county records were clear and nothing was going to change. He said what mattered now was making sure the suspension became permanent, and the best way to do that was to follow through on what I'd said at the hearing and send everything to the county attorney. I told him I'd already started drafting that letter, and he said to make sure it included copies of all the evidence, a summary of the hearing, and a request for the county to issue a formal determination that the HOA had no jurisdiction over my property. He said that once the county made that determination, it would be part of the public record, and the HOA wouldn't be able to come back later and try the same thing with a different excuse. I thanked him and said I'd send him a copy before I mailed it, and he said that sounded good, and to let him know if I needed anything else. I spent the rest of that day finishing the letter, laying out the timeline from Corinne's first visit to the hearing, attaching the deed, the plat maps, the GIS results, the county clerk's confirmation, and the board's suspension letter. I explained that the HOA had fabricated jurisdiction, threatened fines and liens, and conducted a public hearing designed to intimidate me into compliance, all without any legal basis. I requested that the county attorney investigate whether the HOA's actions constituted fraud or abuse of authority, and I asked for a formal written determination confirming that my property was not and had never been subject to HOA control. I printed 2 copies, one for the county attorney and one for my records, and I mailed it the next morning with delivery confirmation. 3 weeks later, I received a response from the county attorney's office. The letter was on official letterhead, signed by an assistant county attorney, and it was longer than I'd expected, nearly 2 full pages. It said the office had reviewed my complaint and the accompanying documentation, and they had contacted the Riverbend Estates HOA board to request copies of any filings or approvals related to the claimed boundary extension. The HOA had been unable to provide any such documentation. He said boundary extensions require public hearings, and landowner notification neither happened here. The letter said that based on this review, the county had determined that my property was not within the jurisdiction of the Riverbend Estates HOA, and any claims to the contrary were without legal merit. It said the county had advised the HOA board in writing that any further attempts to enforce regulations or assess fines against my property would be considered harassment and could result in legal action by the county. It concluded by saying that a copy of the determination had been filed with the county recorder's office and was now part of the permanent public record. I read the letter 3 times, slowly, making sure I understood every word, and then I set it down and looked out the window at the land that stretched away in every direction, the same land I'd been defending for months. It was over. The county had confirmed what I'd known from the beginning, that the property was mine, and no one had the authority to take it or control it or dictate what I did with it. Corinne's fabricated jurisdiction, her threats, her fines, her hearing, all of it had collapsed under the weight of the truth, and now it was documented in a way that couldn't be undone or reinterpreted. I called Nolan and read him the letter, and he said that was the best possible outcome, that having the county's determination on file meant I'd never have to deal with this again. He said he'd heard through someone who lived in the subdivision that Corinne had resigned from the board 2 weeks ago, that the fallout from the hearing had been significant, and several residents had started questioning other decisions the board had made under her leadership. He said there was talk of restructuring the board and bringing in an independent management company to handle enforcement, which would make it harder for anyone to pull the kind of stunt Corinne had tried. I asked him if he thought she'd face any consequences beyond resignation, and he said probably not, that unless someone filed a civil suit, the county wasn't likely to pursue criminal charges for something that had been resolved without financial damages. I said I wasn't interested in going after her personally, that what mattered to me was protecting the property and making sure no one else could try the same thing. We talked for a few more minutes, and before we hung up, he said he was glad I'd pushed back instead of just paying the fines and moving on, because people like Corinne relied on others being too tired or too intimidated to fight. I told him I'd learned a long time ago that the truth was worth defending, even when it required more effort than the alternative, and he said that was a good principle to live by. I spent the rest of that afternoon walking the property, checking the fence lines and the irrigation system and the barn that had started this whole thing, the barn that Corinne had said didn't meet standards and needed to be repainted or removed. It looked the same as it always had, weathered but solid, doing the job it was built to do, and I realized that was all I'd ever wanted, to be left alone to take care of what was mine without someone inventing reasons to interfere. The land was quiet, the way it had been before Corinne showed up, and I stood there for a long time just listening to the wind move through the grass and watching the light change as the sun dropped toward the horizon. The fight was over. The authority she'd tried to manufacture had been dismantled, and the only thing left was the work I'd been doing all along, the work of maintaining something that had been in my family for generations and would be there long after all of this was forgotten. Sometimes the hardest thing to do is stand your ground when someone tries to take what's yours, but the truth is always worth defending. If this story reminded you that facts and patience can dismantle even the most confident bluff, I'd love to hear your thoughts in the comments below. Have you ever faced someone who thought authority meant more than evidence? Subscribe to Karma Fence for more stories where quiet persistence wins, and share this with anyone who needs to remember that fabricated power always crumbles when someone finally asks for proof.